Hello, everyone, and welcome to our regular Wednesday night CPD. We brought to you live, and this will be our first in a series of medical legal talks brought to you by a sponsor for this series, Dr. Shield. If you look at the page, we have a link to Dr. Shield for those of you interested in getting practitioner indemnity. Dr. Shield will be bringing, we hope to bring monthly medical legal talks, and the first will be tonight. And I'm very pleased to um, introduce to you Puan Fazliza binti Azli, who is with the legal firm JJ Chan, and they have vast experience in medical legal issues. So she will be talking to us today on medical disciplinary proceedings in Malaysia. So I hope this will be of interest to you, and certainly it is of interest to me. But before we begin, I have some housekeeping announcements. Okay. Now, don't get excited. This is not the QR code for CPD points. Every time I show this, we have people saying, code not valid, code not valid. Not every QR code is for CPD points, please. Yeah. So this code is for you to get onto the Slido app. You can either use the slido.com link for your browser, or if you have the mobile app, you just either enter the code 39386, or you can just scan it with your QR or barcode scanner to get into the Slido interactive Q&A. So you can use that to ask questions at the end of the talk. Okay. If you're watching this presentation from our CPD page, which is dobbs.my/CPD, the Slido is embedded there. So you don't have to open a Slido app separately if you're watching it. Okay. Now, this talk is entitled to one MMA Approved CPD Point, and you get the point by scanning with your MMA app. If you look at the circled scan QR at the upper left of the MMA app, you will scan the QR code, which will be displayed only at the end of the talk. Okay. Now, I've already sent out an email to all of you that you cannot view the talk with your mobile and try to scan with the same mobile phone. It will not work. You will need two devices, one to view the talk, and when the QR code is presented, you scan with your mobile phone. Okay, the one which you have the MMA app on. Okay, you cannot view the talk with a mobile phone, and there's no way to scan the code with the same mobile phone at that time. Okay, I will show the QR code here at the end of the talk. Now, for those of you who were not able to catch this presentation live, the module will be available for non-live, not quite offline. It's non-live in our bulletin board. Watch out for a keyword which I'll mention at the end of the talk also, because one of the questions will be to ask you what was the keyword mentioned in the talk. Okay, so without further ado, I'm going to introduce Puan Fazliza. Now, this is a pre-recorded talk, so I'm going to share the presentation, which she recorded earlier. We hope there will be no glitches like that. Okay. Puan Fazliza will be here later to take questions. So let's hope the internet doesn't fail us and we have a smooth presentation. Okay.
Hello, good evening, everyone. My name is Fazliza binti Azli. I'm from Mr. Chan Banting and Company, or it's known as CBE. Today, my presentation would be on this topic, an insight into medical disciplinary proceedings in Malaysia. Obviously, first of all, there must be a complaint lodged by the complainant or by the information against the registered medical practitioner. Upon receipt of a complaint against a registered medical practitioner, or is known as RMP, an investigation will commence when the Preliminary Investigation Committee, or is known as PIC, convenes on a date set for investigation of the state complaint. Once the PIC decided to proceed with the investigation, the PIC bears the primary responsibility and authority to find out whether there are sufficient grounds to support the allegation or facts in issue. In this regard, the PIC shall notify the registered medical practitioner within 30 days upon receipt of the complaint and require the registered medical practitioner to submit a reply within 30 days of receipt of such notification from the PIC. And if necessary, request for clarification or further documentation from the registered medical practitioner to be provided within 14 days of a request by the PIC. On this further documentation, usually will be referring to the medical record or the medical report pertaining to the patient, or if at all, it would be an expert report in order to support in terms of the care management of the registered medical practitioner, whether it's acceptable or otherwise. And in the event that the complainant is not traceable, and after looking through the complaint lodged by the complainant and the facts do not constitute a disciplinary matter, or at the very least, the PIC has reason to doubt the truth of the complaint or information, the complaint therefore would be dismissed summarily. And upon considering the registered medical practitioner reply and further clarification, and if the Preliminary Investigation Committee feels that there's a basis to the complaint, PIC may then recommend to the council may recommend to the council for an inquiry to be held by a disciplinary board to decide further on the particular matter. All right. In the event that the disciplinary board decided to proceed further with the investigation, at the outset, an interim order can be given by the disciplinary committee with a view to protect the members of the public or for public interest. The types of interim order that can be given is on, basically there are two. One is on the interim suspension order, and the other one is on the interim restricted registration order. For the interim suspension order, basically, it is a suspension of the registered medical practitioner registration for a period not exceeding 12 months. That is called interim suspension order. Whereas for the interim restricted registration order, merely it means that the medical practitioner can continue with the practice, but subject to compliance with requirement or restriction imposed by the disciplinary board, which they may think fit in order to avoid further complication or issues arising, from his practice. And this will take place for a period not exceeding 12 months as well. Once interim orders being given, it would be reviewed for every 6 months from the date of the order. And the subsequent review would be before the end of 3 months from the previous review. as long as the order continues in force or when new evidence becomes available to the DB. As I mentioned earlier, the interim order shall not exceed the period of 12 months. And for the extension, it is actually up to the President of the Medical Council to grant some extension for 6 months, and each time extension is sought by the DB. Prior to the proceedings, the disciplinary board shall be writing to the complainant requiring his attendance and his witnesses before the DB at a specified time, date, and place. DB shall also write to the registered medical practitioner informing of the same, i.e. on the time, date, and place, to enable the registered medical practitioner to be present with or without legal counsel. Both complainant and the registered medical practitioner have the right to be present with or without legal counsel with equal rights of representation. And before the commencement of the hearing before the disciplinary board, this documentation will be provided. First, the complainant or informant's letter. Secondly, the respondent's reply and clarification. Thirdly, on all other documents which is relevant pertaining to the complaint. The disciplinary board, if at all, shall complete the inquiry within 6 months of its date of appointment, unless an extension being granted by the council. During the proceeding of the inquiry, the disciplinary board chairman will introduce the members of the DB, his legal advisor and secretariat, the complainant, the registered medical practitioner, and those present with him will be asked to identify themselves. Then the disciplinary board chairman will ensure that all relevant documentation and laws to be referred to are in order and shall explain the inquiry procedures, responsibility, and authority of the disciplinary board. A certified interpreter or translator may be made available during the proceedings, and the complaint shall first present their complaint before the disciplinary board. So with this, basically, it is called as examination of complainant, where the complainant would present their complaint before the board, and the disciplinary board would inquire further from the complainant of relevant information. So once that is done, if the registered medical practitioner or the respondent is represented by a solicitor, therefore the registered medical, the doctor's lawyer basically would be doing the cross-examination, meaning to ask further questions to complainant and to obtain relevant information, basically to show that there's no basis to the complaint. And once that is done, the disciplinary board would re-examine the complainant if necessary. Once we are done with the complainant, then the next step would be the same process where the examination by the disciplinary board for the witnesses produced in order to support the complainant's complaint. It follows by the cross-examination by the doctor's lawyer, cross-examination on the witnesses, and subsequently the re-examination by the disciplinary board if necessary. Once we are done with the examination, i.e. asking questions to the complainant and also to their witnesses, therefore parties, the complainant and also the doctor, they must submit before the disciplinary proceeding, the disciplinary board, as to why the complaint should be maintained and as to why the complaint should be dismissed, if at all. In the event that the disciplinary board decided to is of the view that there's a basis to the complaint, the DB would decide to decide for the doctor to submit their defense before the disciplinary board. Or in the event that there's no basis to the complainant, then of course the disciplinary board would recommend to the council that no further action to be taken. As I mentioned earlier, in the event that the disciplinary board decided to frame charges against the respondent, DB will issue a call letter to the respondent or to the doctor indicating the date, time and place of the inquiry. And at the end of the day, yes, the registered medical practitioner has the right to produce any witnesses or documentary evidence to support his defense. And of course, the doctor do have their right to legal counsel as well. Once charge being framed, it would be in respect of the circumstances surrounding the case in specific, clear, precise, and accurate terms, and the offence allegedly committed in specific, clear, precise, and accurate terms. If, for whatever reason, the doctor decided not to put forward any defense or to call any witnesses in support, it is always up to the disciplinary board jurisdiction to proceed further with the matter and to recommend to the medical counsel, that the registered medical practitioner is guilty of the charges framed against him. So at the defense stage, it would be the same procedure as the complainant stage, where the DB shall be recording the statement from the respondent, i.e. the doctor. The respondent doctor may be required to produce any relevant materials before the DB. Basically, for this, we'll be referring to the medical report, the medical record, or the expert report, or at times literature, which may support the defense of the doctor. Once that is done, the disciplinary board will start to question the doctor in terms of the facts of the matter, the conduct, and subsequently the complainant would be putting across his questions to the doctor, and the disciplinary board would be doing the re-examination if necessary. The same goes for the respondent's witnesses, the same procedure. On the postponement, it is only up to maximum of 2 postponement would be allowed with a valid reason. And in the event that the witnesses were to be absent, only a maximum of 3 chances would be given to both parties to appear before the DB. And if the complainant fails to appear for whatever reason, the disciplinary board may recommend to the council to dismiss the complaint or information. And if the registered medical practitioner fails to appear, the inquiry may proceed in his absence. Upon hearing the submission or the defense by the registered medical practitioner, in the event that there's no sufficient grounds to support the charges, the disciplinary board would recommend to the council that no further action to be taken. And in the event that there's sufficient ground to support the charges, obviously the disciplinary board would inform the registered medical practitioner of the decision and reasoning, and therefore the respondent, i.e. the doctor, may enter a plea in litigation, and subsequently the disciplinary board would decide on the punishment. Decision by the medical council. Upon considering the record, recommendation and grounds for the state recommendation of the DB, the council may decide either first to accept the recommendation of the disciplinary board and impose the punishment as recommended by the disciplinary board. There are 3 types of punishment. First of all is for the registered medical practitioner to be reprimanded. Secondly, on the suspension. And thirdly, to be struck off from the registrar. And as I said, in the event that the council decided to accept the recommendation, then it can impose the punishment, or if at all, the medical counsel can always direct the disciplinary board to reconvene the meeting and to inquire further into the complaint or the information. Thirdly, direct that a new disciplinary board to be constituted and conduct inquiry into the complaint or information. Fourthly, direct that the charge be dismissed if the council finds that no case has been made out against the registered medical practitioner, or if at all, to reject the recommendation of the disciplinary board and make its own decision. As I mentioned earlier, under Section 30 of Medical Act 1971, the outcome to be decided by the medical council, it would be in threefold. In the event that the DB is of the view that there's a valid complaint, i.e. reprimand, suspension, and also struck off from register. In the event that there's no basis to the complaint, then of course the complaint would be dismissed. In terms of the suspension, it would be for a period of 2 years. And in the event that the registered medical practitioner is aggrieved by the medical council decision, meaning that you're not happy with the decision, the last option would be to appeal to the High Court within 30 days from the date of the decision. I believe that is the gist of the disciplinary proceedings in Malaysia for the registered medical practitioner.
Okay. Thank you for the excellent talk, Puan Fazliza.
Yeah, we are most welcome.
Yeah, okay. Now, I just want to share the screen again for the flyer. Yeah. Let me make that full screen. Okay. So if anybody has any questions, we are using Slido. Again, don't get excited. This is not the QR code for your scanning the CPD points. Huh? So don't try to use the MMA app to scan and you'll get an invalid code. Okay, this code is for you to get to Slido and then you can ask us the questions. I will now switch to Slido and let's see if anybody wants to ask any questions there. Okay, there's a question from Dr. Lim Kwan Ju, and he's asking, can the council overrule decision of the PIC recommendation to summarily discharge the case?
Yes, obviously the council can do that. As I mentioned earlier, the first stage would be the hearing before the Preliminary Investigation Committee, or is known as PIC. And once we have passed that stage, PIC will make the recommendation before the council, and the council has the right whether to maintain the recommendation by the PIC or otherwise.
Okay, thank you. So there's a question from Dr. Kaur. Can a doctor refuse to respond to the complaint?
As mentioned earlier in the slide, in the event that the doctor refused to respond to the complaint, the hearing of the inquiry will still proceed, even without the written explanation by the medical practitioner. Because at the end of the day, it needs to be seen to the public that there's no issue of favoritism on the medical council to hear the complaint lodged by the patient against the medical practitioner. So in the event that for whatever reason, the medical practitioner decided not to attend to the hearing, or basically prepare a reply to such a complaint, it will still proceed with the hearing, with the inquiry.
Thank you. Dr. Hon is asking who are members of the DB, the disciplinary board.
Members of the DB, okay, at least 3 members of the council, which is at least 10 years of good standing with current practicing certificate, and 1 lay member selected from the disciplinary panel appointed by the council. And the council will also appoint a chairman amongst the members of the DB. The quorum of DB shall be 5 in total.
Okay, hope that answers your question, Dr. Hon. Any other questions? Actually, I have one. You mentioned something about the interim order right at the beginning of the disciplinary proceedings.
Yes.
The PIC may issue an interim order which results in the suspension of the doctor up to 1 year, if I'm not mistaken.
Yes,
Is
correct.
there any avenue for appeal?
And
it seems
like, it is subject to review every 6 months.
But is there any avenue for appeal?
Yes, in fact, the registered medical practitioner can always appeal to the minister on the interim order. So that would be the avenue. Because at the end of the day, it would all depends on the nature of the complaint. And if the medical council is of the view that the nature of complaint is pretty serious, then of course an interim order can be given. And if the registered medical practitioner is aggrieved with the decision, the appeal can be lodged, but it must be before the minister.
Yeah, because the complaint can be serious, for example, an alleged sexual assault or something like that. But it may not be true because maybe the complainant has mental issues or something, and then the practitioner ends up suspended for that, and there's no avenue, so it's maybe quite frustrating for the
Yes.
Yeah.
I can understand that, but so far, based on my experience, the MMC has ever imposed such an interim order upon the practitioner in view of the gravity of that particular order. And in the event that there's no new evidence available, the medical practitioner can always submit before the council to enable them to review such a decision, although the 6 months period has yet to that.
Okay, thank you for that. There's a question again from Dr. Lim Kwan Ju. Can the DB hearing proceed if the complainant or respondent cannot be traced?
If the complainant cannot be traced, at the end of the day, the complaint would be dismissed. Because at the end of the day, the disciplinary board, they need to determine that it is actually a genuine complaint and such person do really exist.
Okay. There's a question from Dr. Gayatri. What happens, I don't know, let me hang on a second. Okay. What happens if the RMP cannot be contacted, but is found to have elements of probable ethical misconduct?
I don't think that would be the situation, because I believe that for each and every doctors, they must be registered with the MMC. And I'm sure that, in terms of the place of practicing and also address will be given. I don't find a situation where the RMP cannot be contacted. If we are talking about complainant, yes, but not so much for RMP. And as I mentioned earlier, even if the RMP decided not to provide any explanation to such a complaint, the inquiry can still proceed.
Okay. Question from Dr. Kaur. would the result of the DB affect a medical legal case which is launched later?
Well, it all depends. If the disciplinary board decision is in favor of the practitioner, of course, when it comes to medical legal cases, we tend to produce such a decision by the disciplinary board. And in the event that it is otherwise, it is basically our role as a lawyer to inform the court that such a decision should not be considered because it's separate proceedings. In which we have come across, like where I represented a medical practitioner in the disciplinary proceeding, which at the end of the day, the outcome is not favorable, although it's just a reprimand. But we will try our best, basically, not to allow for such recording or decision to be produced before the High Court. So the distinction must be made that this is more an ethical issue, whereas for medical legal, it is more for negligence. It has nothing to do with the etiquette of the doctor. It's more on the care management, in attending to the patient. So there's a distinction between the two.
Okay, thank you for that. Dr. DB, Dr. Lim, asked, what about the respondent if the respondent cannot be traced?
Respondent would be the consultant, the doctor, directed. As I mentioned earlier, I don't think there's a situation where the registered medical practitioner, it cannot be traced. It's always been a case where the complainant cannot be traced, not so much on the registered medical practitioner.
Okay. I suppose if the complainant cannot be traced, then the whole thing is dismissed.
Yes, correct. Yeah, because at the end of the day, the board need to determine, to verify that it's actually a genuine complaint.
Okay. Question from Farah. Is it common for MMC to receive complaints from doctor to doctor?
I handled once before, from one doctor to another doctor. So I believe that perhaps it's common because anyone can always lodge a complaint against a registered medical practitioner as long as it involves issues, ethics issues. So it's not necessarily to be a patient.
Okay. But I suppose that would be far less common.
Yeah.
Yeah. Okay.
But it happens before, in which we attended to such a complaint, from one doctor against another doctor.
All right. Okay, now we move on to another question. Are doctors in the Ministry of Health subject to the same proceedings?
Yes. There's only one inquiry proceedings against the registered medical practitioner. Therefore, it covers the government hospital as well as private setup. So the procedure is the same because at the end of the day, there's only one medical act that we are referring to. So
it's the same council, same disciplinary board, which will subject the practitioner to the same proceedings. I think here the doctors who are in Ministry of Health have to realize that the government is not going to cover them in case of disciplinary hearing. If you need medical legal advice and you want the help of a lawyer in the disciplinary proceeding, they have to fork out their own money to hire the lawyer unless they have practitioner indemnity. Is that right? We covered that a lot earlier. So one of the reasons why a government doctor may want to have medical insurance or practitioner indemnity insurance is this instance when although you're employed by the Ministry of Health, you may be subject to the disciplinary proceeding. You never know, okay, in this day and age. And then if there's a complaint made against you, either by a patient or even a fellow doctor. And then if you want to seek legal recourse, you're on your own. After what Puan Fazliza had gone through all the complex proceedings, I think I would be very daunted to stand up for myself without any legal counsel. Yeah, okay, so it's something to consider. So if you I think the doctors in Ministry of Health, if you need to have that safety net, I think it's something to consider getting your own practitioner indemnity. Yeah.
Yeah, I think it's better to get a legal representation at the initial stage itself, just to make sure that everything is covered. Because at the end of the day, if the registered medical practitioner is not happy with the decision of the disciplinary board, as I mentioned earlier, the next avenue would be appeal before the High Court. If certain points not being raised or canvassed at the initial stage, therefore it cannot be raised subsequently at the High Court. So all this is very technical, in which those in legal line, we know what to look for and basically what to ask. So it is pretty important, at the initial stage itself, the doctors must have a legal representation, although it's only an inquiry before the disciplinary board or PIC.
Okay, we better move on. And Farah asks, how long does it take for the disciplinary board or MMC to decide if they're going to proceed with the stage of this defense? Some rough idea.
It would be around 3 to 4 months for the DB to deliberate or medical counsel to deliberate on the matter after hearing the statement given by the registered medical practitioner. It will take quite some time, usually within 3 to 4 months.
Okay, 3 to 4 months dragging on.
Yes.
That's hard. Anonymous, sorry, you should put your name so at least we can address you. Ask, what legal channel can a respondent seek if he or she is suspended from medical practice?
It would be an appeal before the High Court. It would be by way of judicial review, meaning we are appealing against the decision of the disciplinary board. That would be the final recourse. And in the event that the High Court decided to maintain the decision, the last resort would be to lodge an appeal before the Court of Appeal.
Okay. The High Court is not the apex court, isn't it? It's the...
So for disciplinary matters, Court of Appeal would be the apex court. In normal circumstances, Federal Court is the apex court.
Oh, okay.
Yeah. But for disciplinary matters, it will be before the Court of Appeal at Putrajaya.
Okay. Oh, next question. Dr. Horn asks, can an RMP sue for frivolous complaints? Otherwise, after it's been thrown out by the disciplinary board?
Basically, this is quite a very common question posed by the RMP after them going through the inquiry or at the end of the day medical legal cases. Yes, it can be done, but it would take quite some time, for the matter to be litigated. And I believe that it's going to be an uphill task because it's just that the patient decided to complain, and whether there's a basis to such a complaint, otherwise it's very subjective. So if you were to subject a patient or complainant to be sued after a decision being made, it is really going to be a tough task, and it will take such a long time, and also in terms of monetary costs in which you'll be incurring, because we would not know at the end of the day whether the High Court judges will be with you or otherwise.
Okay. Can the complainant provide witness or new evidence during the stage of defense? Ask Farah.
Yes, that can be done. Even for me, we even produce an expert to testify on behalf of the RMP in the disciplinary inquiry. So that can be done. So usually for the doctors, it's either going to be the nurses to support whether there's such conduct as alleged by the complainant, or if not, it's going to be an expert, to explain certain things.
Okay. No questions anymore. Just if there no questions, I got one last one for Juan Fazliza. What's the best defense against disciplinary hearings? What's the best way to avoid all these things?
Okay, the best defense would be at the material time, the registered medical practitioner truly believe that whatever things being done, that is the correct approach. Because there's a case authority to say that if you believe at that point in time, whatever things you have done is the correct approach, therefore the registered medical practitioner cannot be subject into disciplinary proceedings.
Okay, so that's basically best, if you do best medical practice, adhere to standards,
yes,
document properly, everything. I think that's probably the best defense. Okay, I think that we had quite a number of questions. I don't want to tie out. One more question from Farah. I don't mind taking. Can RMP sue the person who is giving supporting evidence by providing false statements and allegations?
Yes, that can be done, but as I mentioned earlier, it would be a separate avenue where it's going to be before the High Court, where time and cost is involved. So it is up to the registered medical practitioner whether at the end of the day they would like to go through this course. And I believe that, when it comes to a situation where the registered medical practitioner would like to sue the complainant on a frivolous complaint, etc., I believe that, in terms of the cost, it is actually from their own pocket. It will not be covered under the MedMal policy, because MedMal is only for medical negligence where you're defending, and it does not apply in a situation where you decided to sue someone for lodging a frivolous complaint or otherwise, etc.
Okay, we will just take a couple more questions, then we will stop. Dr. Han asked, the Ministry of Health has their own inquiries. If they're not mistaken, yes, I think they do. If the patient is not happy with the resolution, can he still complain to the disciplinary board?
Yes, that can still be done, but of course, at the end of the day, it is up to us, the lawyers representing the RMP, to raise the questions that has been ventilated, and at the end of the day, like he's coming again, trying his luck for the second time before the MMC.
Okay, quickly now, if a complainant provides new evidence on the day one of hearing, can the RMP request for postponement?
We can always apply for adjournment, and it is up to the committee members whether to allow such an adjournment or otherwise. We can always apply. As I mentioned earlier, adjournment would be allowed twice throughout the proceedings.
2 times.
And provided a good reason,
Okay. Why would High Court not take the DB decision? Dr. Kaur asked.
Why would it? All depends, because at times we'll be saying that different consideration being taken by the MMC in deciding on the matter, where such points should not be taken into consideration. This is more on the point of law, where it's for us lawyers to argue, in such a situation. But we will always appeal in the event that the council decided to suspend the RMP or to strike off the RMP. If it's more for reprimand, hardly, the RMP will ask us to appeal further.
Yeah, it has to be a major reason to appeal. Yeah. Okay, I think we've had a very interesting Q&A. Now we will go to what I think everyone is waiting for. Okay, don't scan this. This is not the QR code for CPD points. I'm coming to that. Please hang on. Okay, just a reminder how to scan. You open your MMA app, and then the red circle there is where you tap. All right, and you can scan with your MMA app. Okay, the moment you've been waiting for, here is the QR code. As I told you all right from the beginning, the email sent to all registrants also, you cannot scan and watch with the same device. It's physically impossible. Okay, this code will expire within an hour, so it will not work if you are watching this video as a replay, say 2 hours down the line. So I'll put it up just for half a minute or a minute. Please get your MMA events app up and scan. Do lawyers have a CPD too, Faslisa?
Yes, we do.
And how is it done?
It's a common thing. But I believe that for lawyers, bar council is not being strict about it for now. Although they've been trying, they say that in order for us to renew our practicing certificate, we need to get certain points. But yet that has yet to be implemented. So yeah.
So it's not compulsory.
Not compulsory, but then of course, like for us, if we find that the topic is very interesting, which relates to our practice, then we will sign up for that particular course of talk.
I believe that CPD content should be interesting, and actually I think your talk was certainly very interesting because so many questions coming out of it after that. So that shows there's interest, and it's not just getting the point, with matters. I think at the end of the day we learn something out of every session. I think that's very good. And so far, I think all our live CPD in Dobbs, I think, have generated quite a fair amount of interest. So the next medical legal one, I think the topic also is very interesting. So we all stay tuned once a month. Dr. Shield has been very good to organize all of this. So those of you still not without any this decision about PII, especially the government doctors, now do you hear about disciplinary hearings is not covered by the government, you're on your own, you may want to get your own PII. So Dr. Shield is just one of the options. I like it because it's completely online. So you can get your code and then instantly also get on board. All right. Okay, everybody got their points. Anybody not got their points? I will tell you how you can do that. You can actually visit our bulletin board later. For those of you who have not watched this live, you can go to our Dobbs bulletin board, so dobbs.my/forum. This is the direct link to the board, but if you can just go there and then log in and search for the CME module, you can view all the past talks, including this one. Will give us a day or two to put up the recording, and then you'll be able to answer some questions. Aside from the MCQs, we'll also have a keyword. Okay, so listen carefully, because the keyword is going to be one of the MCQs, and the keyword is Apple. APPLE. If you don't know how to spell it, it's Apple. All right. Okay, I'm not going to repeat it anymore. So this is just a test that you watched the video. One of the questions will be the keyword. Okay, so I think without further ado, I just want to thank Puan Fazliza again for the wonderful talk and the insight into medical disciplinary hearings, and how practitioners may need to undergo all this if they are called up. So thank you once again. We can't give you a virtual clap, but I think I think
it's my pleasure.
Everybody appreciates your effort.
Thank you as well for inviting me. It's a pleasure.
Yeah. Okay, so good night, everybody. I'm going to end the broadcast.
Glad to hear that.
You can still watch it, and within an hour, you may be able to scan the QR code for your point. But after that, if it expires, do visit the bulletin board, and then but the module won't be up yet for another day or two. So we'll need some time for the video to be processed. Okay. All right. So good night. Thank you again, Puan Fazliza. All right. Yeah.
Okay.